right, good morning again. Welcome, everyone. We're here on the matter of Holtec International's application to construct and operate a consolidated interim storage facility for nuclear waste in Lee County, New Mexico. And I should mention that in addition to this room being open to the public, we are making available this proceeding on listen-only telephone lines so that interested members of the public who cannot be here can follow this today if they so choose. I'm Judge Ryerson. I'm trained as a lawyer. I chair the particular Atomic Safety and Licensing Board that the NRC has assigned to this case. On my left is Judge Trikuros, who is a nuclear engineer, and on my right is Judge Arnold. Dr. Arnold is also a nuclear engineer. Today's proceeding concerns 6 hearing requests that the NRC has received, challenging aspects of the application that have been filed by Holtec. And we'll list them by name when we take the appearances of counsel. We also have before us 5 petitions to participate in this proceeding as interested local governments, and these have not been opposed. Before we take the appearances of counsel, I'd like to review how we intend to proceed today. I think we pretty much set it forth in the order that we issued on January 10. Again, our principal purpose today is to hear arguments on the hearing petitions, to determine whether the hearing petitions meet the NRC's requirements to participate in an evidentiary hearing, which, if it's held, will be held at a later stage. Today's arguments are essentially procedural ones. We also have before us a host of related motions, and they may or may not come up today. We're not going to argue them specifically, but they include motions by some of the participants to strike portions of other participants' pleadings. They include motions to adopt parts of other participants' pleadings. They include motions to file new and amended contentions, both of which I think are pretty closely related to Beyond Nuclear's contention and also Sierra Club's contention number 1. And finally, we have motions addressed to the type of evidentiary hearing we should have if we have a hearing. Now, we have read the pleadings that have been filed by all the participants here. They total literally hundreds of pages. So as we said in our order of January 10, we would like to begin with each individual participant with a brief, and I do mean brief, no more than 10 minutes or so, statement of their position if they wish to make one. But then we'll begin with questions for each participant, one after the other. And I should urge that nobody should feel that we are neglecting them if we do not have many questions for them. In some cases, the pleadings are quite clear, I think, as to what the issues are and what the positions of the parties are, and we simply may not need to feel to hear further explanation on some of the individual contentions or even the standing issues. So don't take anything, I hope, from the fact that we may not have a lot of questions for a particular participant. That simply means that we believe anyway that we understand exactly what the issues are. When we ask questions, generally the board will be directing questions in the first instance at the petitioner or participant who's in front of the podium. We have available mics, remote mics. We may ask another participant to comment. Generally, if we want another participant to comment, we will request that. Nonetheless, I think we'll be relatively informal here. If anyone has an uncontrollable urge to comment on somebody else's response, raise your hand. We may recognize you, but if we don't ask, better in most cases to simply wait your turn. I don't know if we have here, we'll check when we have the appearances, if we have representatives of the local governments, but we will find time to fit in statements by any of the local government petitioners who would like to make them. But their petitions, as I think I said, are not opposed, and so they really don't have to say anything at all unless they want to. Logistics. We will take at least one short break in the morning and the afternoon, perhaps two. We will break for lunch, I think, at the first convenient opportunity afternoon. And today we will finish by 4:30. We've promised the building that we will have everybody out by 5. So we really should try to wrap up, I think, by 4, and then people can straggle out and be out of the building by 5. What else? Before we take the appearances, any comments, Judge Arnold? The length of Judge Takuros? A lunch, I think there's no cafeteria in this building, so we're probably going to take a relatively long lunch, an hour and a half, so people can not only easily go someplace to eat, but also perhaps have a chance to discuss issues if that's helpful. Anything else, Judge Takuros? Judge Arnold? Okay. What I'm going to do now is ask the individual counsel and representatives to come to the podium and identify themselves. If you have questions about what I just talked about, this would be a good time to ask them as well. So let's begin with Beyond Nuclear.
Good morning. My name is Carolyn Reiser, and I will be appearing on behalf of Beyond Nuclear.
Good morning. Welcome.
I don't know if you want each of us to come by ourselves, but I'm Diane Curran. I'm appearing on behalf of Beyond Nuclear, and also with us today is, shall I just introduce her, or would you like her to come up? Mindy Goldstein.
You may introduce them from your podium.
We have with us this morning Mindy Goldstein, Director of the Turner Environmental Law Clinic, also appearing on behalf of Beyond Nuclear, and 2 law students. Alex, what is your last name, Alex? Pierce. And Marguerite Mills.
Thank you. Welcome to all of you. And who will be speaking, Ms. Curran? Will both of you be speaking?
Ms. Reiser and I will be speaking. She'll be delivering the opening statement, and I'll be answering questions.
Okay. Thank you. The Sierra Club.
I'm Wallace Taylor on behalf of the Sierra Club.
Good morning, Mr. Taylor. Thank you. Welcome. Alliance for Environmental Strategies. I think I have it right. It's appeared 2 different ways in some of the pleadings, but do we have a representative? Yes.
I apologize for the confusion. I caused it. I'm Nancy Simmons. I'm here for the Alliance for Environmental Strategy.
Thank you. Welcome, Ms. Simmons. All right. I'm going to refer to them after this moment as joint petitioners, but we have, I believe, one council representing, and tell me if I don't have this right, Don't Waste Michigan, Citizens Environmental Coalition, Citizens for Alternatives to Chemical Contamination, Nuclear Energy Information Service, Public Citizen, San Luis Obispo Mothers for Peace, and Nuclear Issues Study Group. I believe that you represent all 7, is that so?
Yes, sir. Good morning. My name is Terry Lodge.
Mr. Lodge, you appear to be what we used to call in private practice a rainmaker, so I congratulate you.
If that is so, Your Honor, I'm drowning. Thank you.
Thank you. Welcome to you. Next is, I think it's pronounced NAC. It's not NAC, but NAC. Is that correct? NAC International? NAC. Okay. Thank you.
My name is Sachin Desai. I'm appearing as counsel for NAC International. Along with me is Daniel Stenger from Hogan Lovells Law Firm, also counsel for NAC International, and Robert Helfrich, who is general counsel for NAC International.
Thank you, Mr. Desai. Welcome to you. Welcome to you all. Let's see. Next, and you can satisfy some confusion I have here. Actually, Fasken Land and Minerals and Permian Basin Land and Royalty Owners.
Yes. Good morning, Your Honor. My name is Robert I, and I do represent those parties.
Okay. Thank you, Mr. I. The question I have is, I think I'm correct. Fasken Land and Minerals is a member of the Permian Basin Group, but are you representing each of them separately as well?
Yes.
Yes. Okay.
Yes.
Thank you.
Thank you.
Let's see. That's it for the petitioners. Now, Holtec International.
Good morning, judges. I'm Jay Silberg at the law firm of Pillsbury Owens of Shaw Pittman, representing Holtec International. Here with me representing Holtec International from Pillsbury are Tim Walsh and Ann Leidick, and we'll all be speaking in response to your questions. I will be delivering the opening statement.
Good morning, thank you, and welcome to all of you. The NRC staff. Who do we have for this staff?
Good morning, Your Honor. Sarah Kirkwood for the NRC staff. I'm accompanied by my co-counsel, Joe Gillespie and Alana Weiss. And we also have with us several of our staff members. We have John McCurgan, who's the branch chief for the spent fuel licensing branch, Jose Cuadrado, who's the safety project manager for this project, and Jill Taverley, the environmental project manager.
Thank you, Ms. Kirkwood. Welcome to all of you. Next, and I'm not sure if we have them all here or not, but we have, as I said, 5 petitioners to participate in any evidentiary hearing, if we have one, as local governments who have a special role in our hearings under the rules. The first I'll mention is, and I may be mispronouncing the county, is it Eddy or Edie? Eddy Lee, the Eddy Lee Alliance. Do we have anyone? Yes.
Mr. Chairman, my name is John Eaton, and I am the Vice Chairman of the Eddy Lee Energy Alliance.
Thank you, Mr. Eaton. I have a question for you.
Yes, sir.
First, do you intend to speak for a few minutes today? We're certainly entitled.
We would like to. We have 3 members here that would like to speak, and 2 of the county commissions would like to have members to speak, and then one of the members for representing the city of Carlsbad could not be here today because of commitments tonight, but is going to come tomorrow if the hearing goes on, and he would like to speak then.
Okay. The second question I had for you was, do you plan to stay, if we go 2 days, do you plan to, I know you've come some distance, and we could take you today if that matters to you. Otherwise, we'll fit you in as it
Mr. Chairman, I think all of us plan to be here for the whole week 3 and the
We'll find a convenient time then to hear from you. Thank you. So the city of Carlsbad, are you separately represented, or who, in other words, are you coordinating all of the counties and the cities that are involved?
The city of Carlsbad's representative will be here. He's the individual that will come tomorrow.
Okay.
There's nobody from the city of Hobbs.
No one from Hobbs, okay.
Yeah.
And so Lee County, is anyone here separately from Lee?
Yes. Mr. Jonathan Senna.
Okay. Mr. Senna, did you, I'm sorry. You're Mr. Senna. Okay. And you are speaking or not?
Yes, sir.
You are speaking. Okay. And and Eddy or Edie, is it Eddy or Edie? Eddy County, then I think the appearance was entered by Mr., and I'm going to really apologize in advance for his name, Rudametkin?
That's good, sir.
I did get it right.
Yes, sir.
Thank you, sir. And are you speaking independently or?
Yes.
Okay.
Yes. Thank you.
Very good. Judge Arnold, anything I'm sorry.
I belong to a group called Action Leader, Action Leader, and I don't see Janet Greenwald here. She's been very active in this, and the leader of the leader of our group. So if she doesn't come, may I speak for my group?
Have you entered an appearance? Have you filed anything?
No.
Oh, okay. No, this proceeding today is limited to participants, petitioners, the applicant, the staff, and the government entities who have actually filed and asked for an opportunity to speak.
But not the people.
This is a government of the people, by the people, for the people, but you had an opportunity to enter an appearance, and you haven't. So some other time perhaps, but not today.
How come we have to
Because there was a Federal Register notice providing an opportunity to participate, which all of these groups responded to, which 5 different local governments responded to.
Record from citizens' action, you have provided, you have an state.
I'm sorry?
I'm asking someone from an organization that we belong to. He's been very active, and we really, we really support him. I'm just asking him
Okay. 2 things. One, today we are limited to the participants at this point who have filed pleadings in front of us. That's all we are considering. And Judge Kouros reminds me I perhaps should have asked people to turn off their cell phones or silence their telephones for the rest of the proceeding. But thank you. I'm sorry we cannot hear you or anyone else who has not yet filed something today. Judge Arnold, before we start questions. Nothing? Judge Kouros? Thank you. All right. Well, we will begin, as our order said, with Beyond Nuclear. So I'm not sure I caught your name. Is it Reiser?
Yes.
Reiser. Okay. And your opening statement.
Thank you.
Thank you.
May it please the Board. My name is Carolyn Reiser, and I'm a fellow with Emory Law School's Turner Environmental Law Clinic. I'm appearing on behalf of petitioner Beyond Nuclear. This proceeding that we all participate in today is illegal. This adjudicatory body does not have the authority to review a license application that is based on an illegal premise. Although Holtec presents it as an alternative, the mere inclusion of the Department of Energy as an option to be responsible for the spent nuclear fuel transported to and stored at the proposed facility is illegal. The law is clear. The Nuclear Waste Policy Act states affirmatively that the U.S. government cannot take title to privately produce spent nuclear fuel until a final repository is operational. There is no dispute that no final repository is operational, let alone even licensed. Thus, Holtec's application is based on an illegal presumption, and the application should be dismissed. By conducting these proceedings, the Nuclear Regulatory Commission has impermissibly allowed Holtec to undermine long-standing United States law established in the Nuclear Waste Policy Act. However, regardless of established law, the Commission has directed that this proceeding for the moment will continue. In accordance with that wish, Beyond Nuclear has shown, and will continue to show today, that it both has standing to pursue this claim and that the Holtec application violates the Nuclear Waste Policy Act. First, as the NRC staff agree, we established that Beyond Nuclear has standing. Our members live, work, recreate, and frequent the fence line of the proposed Holtec facility. They are mineral owners whose financial interests are threatened by the presence of nuclear waste, limiting their ability to extract their resources. They are ranchers who currently ride horses over the very land that Holtec proposes to use to store hundreds of thousands of tons of nuclear waste. They are families whose children pass across the Holtec land every weekday just to get to school. Suddenly, their land is no longer pastoral ranch land, as it has been for 100 years, but instead will be overshadowed by the largest nuclear waste dump in the world, lessening the value of the land for any other purpose. Suddenly, just driving on what is essentially their main street, Highway 62-180, will mean consistently exposing themselves and their families to doses of radiation as they drive along this highway on their way to work, to school, or just to see a movie in town. They will be exposed to radiation from shipments of nuclear waste paralleling the highway on the way to the Holtec facility. Beyond nuclear members will not be able to escape being next to the 173,000 metric tons of spent nuclear fuel that Holtec plans to store in their backyard and ship along their main street. The amount of nuclear waste is more than twice the amount that the U.S. currently has, and more than twice the amount that was proposed to be stored at the Yucca Mountain Permanent Repository. No one will be more harmed than these individuals by the licensing of this facility. If you do not grant them standing, you will be declaring this neighborhood a national sacrifice zone without giving it an opportunity to be heard. Next, Beyond Nuclear has shown, and will show further today, that the Holtec application's central premise that the Department of Energy must take title to the nuclear waste at the interim storage site violates the Nuclear Waste Policy Act. And by entertaining this application, the Nuclear Regulatory Commission violates the Nuclear Waste Policy Act and Administrative Procedure Act. The Nuclear Waste Policy Act is Congress's comprehensive scheme for the interim storage and permanent disposal of high-level radioactive waste generated by civilian nuclear power plants. It is the result of brilliant and wise balancing on the part of Congress that establishes distinct responsibilities for the federal government and private generators regarding spent fuel, with the ultimate goal that nuclear waste will end up underground in a permanent repository. By seeking a license that would allow the federal government to take title to the spent fuel at an interim above-ground storage site, Holtec flouts the Nuclear Waste Policy Act and its important balancing. Holtec attempts to skirt the question of who may legally own the nuclear waste it proposes to store by stating that either the Department of Energy or private owners will be responsible for the spent fuel. But by including an illegal option, the entire application is rendered unlawful. Consider a contract that offers for the purchase of an item, either cash or committing a felony. This contract is clearly unenforceable simply because it includes an illegal option. The legal option does not save it. And even though just offering an illegal option is a fatal flaw, we know that the only real option is the unlawful one. To its shareholders, at press interviews, and in industry presentations, Holtec has always said and continues to say that to complete the facility, it is counting on the Department of Energy being responsible for the waste. Just this month, Holtec reiterated that the facility will ultimately depend on the Department of Energy and Congress. We challenge the application's compliance with the Nuclear Waste Policy Act. But the purpose of this proceeding is to consider contentions brought under the Atomic Energy Act and National Environmental Policy Act. Thus, we think that this board has no choice but to dismiss our contention. To protect the integrity of this licensing board and this licensing proceeding, we ask that the board take note of the violations of the Nuclear Waste Policy Act and the Administrative Procedure Act. Thank you.
Thank you. Ms. Curran, are you going to answer questions? Yeah, we're going to ask questions after each opening, I think. Ms. Curran, I understand the Beyond Nuclear's position to be that we really shouldn't be considering this issue. You wanted the commission to consider the lawfulness under the Nuclear Waste Policy Act of this application. And through the secretary, the NRC declined to do that. I think you have appealed that, correct? If I'm correct, to the D.C. Circuit, and that is, I assume, probably stayed pending our decision?
We've made a motion to hold a proceeding in abeyance pending further proceedings here. The NRC has opposed our motion and has said it's going to move to dismiss our lawsuit, but none of that has been decided yet.
Right. Okay, thank you. Well, I know that in addition to thinking we shouldn't have this issue, you have raised some questions about whether Holtec really has two options on the table. But for the next couple of questions, let's assume that Holtec's position is, as I believe Mr. Silberg has stated it to be, that Holtec wants to either proceed under an arrangement by which DOE would take title to the nuclear waste, or proceed under an arrangement by which the nuclear power companies would retain title to the nuclear waste. The DOE option we'll call option 1, the power company title we'll call option 2. Now, your position, I take it, is clearly that option 1 raises at least a legal issue contention, assuming that there's a contention here, that we should be deciding it at all. Isn't that a legal issue contention in your view?
Yes.
Yes, okay. Now, suppose Holtec changed its mind, and you needn't leap to your feet, Mr. Silberg. I'm not suggesting this is the case, but suppose Holtec changed his mind and said that, well, we're really going to go only with option 2. Would that solve your problem?
Well, it would certainly address the Nuclear Waste Policy Act issue if DOE were not named at all.
Correct.
And it were similar to, say, the private fuel storage case where everything was done by private licensees.
Okay.
Yes, that would solve that problem, and we may come back with other problems, but yes, that one would be solved.
Thank you. And I recall that in Holtec's pleadings, and I really haven't often seen this, there was a suggestion that neither Holtec nor the NRC staff in their pleadings, I believe, directly addressed the lawfulness of what we'll call option 1, the DOE title position. But Holtec did note that there is the possibility of pending legislation in the Congress that would amend the Nuclear Waste Policy Act. Suppose Holtec, and again, Mr. Silberg, I'm not suggesting you're proposing this, but suppose Holtec said, okay, we will modify our application to say that option 1 is conditioned on congressional legislation that amends to clarify that the Nuclear Waste Policy Act permits DOE to take title in these circumstances. Would that solve your problem?
No.
No. Why?
The reason being that the current state of the law is that the DOE may not take title to spent fuel unless and until a repository is up and running. And for the NRC to entertain on kind of a hypothetical basis an application that might turn out to be valid in the future would be, we think, a gross violation of the Administrative Procedure Act, which does not allow the agency to do more than Congress has authorized. And there's a recent case I would refer you to, and I'm sorry I don't have the number at the top of my head. It's State of New York versus, the Commerce Department, I think, and the U.S. Department of Commerce. It had to do with the census and the Secretary of Commerce's addition of a citizenship question to the census, which Congress had precluded. And the judge in that case, this was in the Southern District of New York, issued maybe a week ago, said the Administrative Procedure Act, it may seem like kind of it's a basic and boring thing, but It's a statute that kind of maintains the integrity of our government. And if an administrative agency like the NRC goes about entertaining hypothetical license applications that are clearly inconsistent with governing law, then that, we would submit, is a gross violation of the APA.
I think I can anticipate your answer to my next question then. Another purely hypothetical. If Holtec said that it would exercise option 1 only if it went to a court of competent jurisdiction and obtained a declaratory judgment that under the Nuclear Waste Policy Act, having DOE take title and possession would be permissible, that would not solve your problem, I take it.
We would say go to the court first.
Right.
And then come to the NRC. And just bear in mind that Beyond Nuclear's members, and these are the people who contribute to the organization and make its work possible, are people who include people who live near this facility, who do not have endless resources to protest a hypothetical license application. They're spending their treasure to argue about something that may never happen and should never happen unless the law is changed. The government, that's part of the APA, is to be responsible to the citizens of the country who go into litigation because there's a real dispute over laws that are currently in effect, not because there's a hypothetical dispute. This is quite an undertaking for these organizations to do this work. And if we were to, we had the choice of fighting this application because our members are very concerned about this on the many technical grounds that there are to do it. But we chose instead to say, just our group, Beyond Nuclear, is saying, no, this is not appropriate to even conduct this proceeding at this time. If Holtec were to get a judgment from court saying this is legitimate under the APA and the Nuclear Waste Policy Act, then we would have to participate because we had that judicial interpretation. I doubt they would get such an interpretation.
Okay. I have just one, what for you may be almost a moot question. The NRC staff is not opposing the standing of Beyond Nuclear. I believe you have a member who lives about a mile from the proposed facility, and that is the basis on which the NRC staff would agree that you have standing, or at least not oppose standing.
I would just add, we have members that are even closer than that, and that, as Ms. Reiser was saying, they cross the property, they have cattle on the property, they would be going, using the fence line area of the property, so even closer than a mile.
Yeah, so for you, this question is not maybe terribly relevant, but we always appreciate your views, Ms. Curran. And you also have members who are relying upon proximity to potential transportation routes. Is that, you're relying on them as well for standing? I would just want to clarify that we are not relying on proximity standing with respect to transportation. Okay. We are relying, our basis for standing is virtually identical to the basis for standing that was found by the licensing board in the Duke, Kojima, Stone, and Webster case that's cited in our brief. And as a matter of fact, there seems to be some standard determination that if you are within 2 meters of a transportation cast, you are going to get a certain dose of radiation. I can't remember how many milligrams it is, but it's exactly the same number in the Duke, Kojima, Stone, and Webster case as it is in our case. And we are saying that this isn't a case where we're saying railroad cars may go by these folks. We're saying there's going to be 500 shipments a year for 20 years of highly radioactive material that are going to go on a railroad line or a road from the main railroad trunk to the facility. And people drive along a road right next to that railroad track, and people go into the railroad yard where these cars will sit, and they will be within a distance where
they will get a radiation dose. It may be small, but they would prefer to avoid it. It's different from a case where, first of all, we're not saying that's a proximity thing. We're saying that is, we're using the numbers in the environmental report to show that there is an injury to our members. And I think Holtec tried to say, well, the Duke case isn't really good law anymore, but I think if you look at those cases, they're quite different. For instance, in the Pacific Gas and Electric case, the petitioners that I represented said, we cited the Yucca Mountain EIS that said if there's an accident involving a cast, people might be affected within 50 miles. And the board said, well, the doses would be minuscule, like, well, you can't rely on that. But this is really quite different. This is every single day of every single year for 20 years. Railroad cars passing through this area are going to be emitting some level of radiation to the public and onto roads nearby to people who may be nearby.
Yeah. All right. Well, I thank you for that. I think Mr. Lodge's clients may be, some of them, in a slightly different position on that issue. We'll talk to him about that. Mm-hmm. Judge Arnold, did you have further questions?
Sure did. In your petition, you state that this contention is neither within scope nor material to the findings the NRC has to make. Is that still your opinion?
That's a good question. And before the October 29th order from the commission, I would have said unequivocally, absolutely, because the hearing notice that went out about this facility said that this board was going to look at the Atomic Energy Act and NEPA, and there's nothing in it about the Nuclear Waste Policy Act. The commission's order now adds to the licensing board the responsibility to look at our claims. I think so it's gotten a little more complicated, but I think the issue is still the same because it's the hearing notice that still governs. Unless a new hearing notice goes out that says, and we will now entertain questions about compliance of this application with the Nuclear Waste Policy Act, I think you're still limited by the scope of your hearing notice, and the commission did direct you to evaluate our claims in the context of Section 2.309, which raises the question, is this material, is this issue in the scope?
And you did file a contention as a precautionary matter, as I
Yes,
recall.
we did.
Yeah.
Yes, it was a precautionary measure, and we think that the appropriate response for the licensing board is to dismiss the contention for lack of scope, compliance with the scope and materiality requirements, and we would hope you would raise some concern about the APA problems that are raised by the case. We'd love to have your input on that. But we think that you really have no other choice under the framework that you are given.
That was my next question. Under the requirements in 10 CFR 2.309F, contention admissibility standards, would you say that your contention does not meet all of those because you say it's out of scope and not material?
That's right. We had to say that because that's what's true.
So, in your opinion, does a board have the authority to admit a contention where the petitioners say it's out of scope and it's not material?
Well, I think you'd have authority to admit a contention if you thought we were wrong, but I don't see how you could disagree with us. I don't mean to be disrespectful, but I just don't see how anyone could say that the Nuclear Waste Policy Act has any bearing on a typical licensing case, because this really has to do with a whole separate statutory framework.
Okay. One last question on this particular topic. Supposing this board just didn't believe you and admitted the contention, would you have the authority or the ability under the rules to appeal our decision stating that your petition should have been denied? I mean, it's kind of reverse of anything we've ever done before.
I don't believe as an interlocutory matter, if we admitted your contention and found you had standing, hypothetically, I don't think you would have grounds for an interlocutory appeal, would you?
Well,
your hearing petition has been granted in that hypothetical circumstance.
Yeah, we might try to make an argument, but I think if you admitted the contention, we would think of some way to go back to the commission. I'm not sure what it would be, but I think that we would consider that a problem that we would address.
Okay. Now on to a different topic. To your knowledge, does the Department of Energy currently own any spent fuel or greater than Class C waste?
I would think so, but, you know, the Department of Energy has facilities all over the country with all kinds of material in them.
Okay. And in that case, if this license were granted, would the Department of Energy be permitted to store that spent fuel and waste at this consolidated facility?
Well, boy, that's a good question. I would be really surprised, but I suppose that's a possibility and another reason why not to entertain this application. It's kind of opening a can of worms.
Okay, that's my questions.
Judge Chikouros.
Yeah, would there be any reason why the DOE could not provide funding for utility ownership or for utilities transporting and storing this material, but not the DOE not take ownership of the spent nuclear fuel?
I suppose depending on what's authorized by the Atomic Energy Act for the DOE to do, if that's within their powers under the Atomic Energy Act, yes, but I don't think that would solve the problem that Holtec is seeking here. Is that the issue of ownership is basically involved a transfer of liability, which is really a huge issue for private licensees. This is a long-term problem, we know. It's taking a long time to license a repository, and it would help private utilities to be able to shift liability for spent fuel from the private licensees to the Department of Energy. And by giving grants to private licensees, that might help them along somewhat. And I have no idea whether that would be legal, but I don't think it would address the fundamental issue here. And that is a transfer of liability. And this was, I would just recommend you look at COI 02-29, which is a decision by the commissioners about the private fuel storage application, where the state of Utah said that scheme violated the Nuclear Waste Policy Act. And the commission quote a colloquy about why the Congress wanted to set up the legal scheme this way. Congress was worried that if the Department of Energy took title to spent fuel before a repository opened, that this would dilute the incentive for private licensees to get behind a repository, and that storage would become the de facto solution, which is, a major worry for Beyond Nuclear, that if the Department of Energy becomes involved here through taking ownership, that takes away a lot of incentive to find a permanent repository for this waste, political incentive I'm talking about. We all agree that there's a tremendous technical need for a repository, but political incentive is very important. And that once New Mexico had accepted basically the entire inventory of spent fuel to the United States in an above ground facility, a lot of motivation to find a repository would be gone.
But as you mentioned earlier, PFS was to be funded entirely by the private sector and did not include DOE at all.
That's correct. But the commission just explained why the private project that PFS had didn't fit within the Nuclear Waste Policy Act scheme.
Thank you, Ms. Curran.
Okay, thank you.
Let's see. All right, we'll take a break either during the middle or after Mr. Taylor's presentation. So we'll go next to the Sierra Club.
Thank you and good morning.
Good morning.
The Sierra Club is the oldest and largest environmental organization in the country. We have over 700,000 members nationally and about 10,000 members in New Mexico. We are concerned about the environmental consequences of nuclear power in general, more specifically the problem of highly radioactive nuclear waste. That's why we're intervening in this proceeding. This project that Holtec proposes is without precedent. 173,000 plus tons of radioactive waste brought to one spot in New Mexico. Although the environmental report, even the third revision, still says 100,000 tons. Holtec's pleadings have said 103,000 or 173,000, so I'll go with that. It will come from all over the country, mostly by rail, sometimes through cities and urban areas, sometimes through farm areas. I'm from Iowa, so I understand that. And we have to look at the consequences of, first, that transportation issue, and also the sheer scope of this project. As I said, it's unprecedented. The PFS, the project that you mentioned, was only 40,000 tons. The Yucca Mountain Geologic Repository was 70,000. There was going to be 70,000 tons. This project, if we take the 173,000 tons, is much, much larger than either of those. And without the protections and safeguards of a geologic repository, that's our real concern, and why we believe that the environmental report and the safety analysis report are deficient. They really don't address the scope and consequences of this project. So we would ask the board to give this case the consideration that the scope and nature of this project demands. Several of our contentions relate either directly or indirectly to the integrity of the containers in which the radioactive waste would be stored at the Holtec CIS facility. For example, contentions 14 and 20 through 24 raised concerns about the safety, integrity, and monitoring of the containers. Contentions 15 through 19 raised concerns about the impact to groundwater from leaking containers caused by corrosion from salts in the ground and other causes. In recently filed responses to requests for additional information, or RAIs, submitted by Holtec, Holtec has said it will revise the SAR to address NRC staff's concerns about testing for and addressing leaking containers. In response to another RAI, 17-14, Holtec has said the potential for cavity enclosure containers, or CECs, wall thinning will be assessed by visual inspection for any corrosion and or pitting on the interior surfaces of the CEC. Because the CEC is a buried structure, degradation of the coating due to abrasion or other external contact during the life of the CEC is not feasible. Thus, inspection of the CEC internal surface serves as a viable method for determining the potential for any wall thinning due to localized CEC corrosion. So they're admitting there could be corrosion. In another RAI 17-12, the NRC staff recognized the presence of salts that could cause corrosion of the containers, a circumstance Holtec blithely dismissed. These RAI responses were just placed on Adams. The accession number is ML 19016A481 on January 16th. They will change our contentions or form a basis for new contentions. Obviously, we have not had a chance or the time to make an evaluation. 10 CFR section 2.309 allows late filed contentions. One of the conditions for late filed contentions to be recognized is that they be timely filed. The timeliness has been determined to be within 30 days after the new information on which the contention is based becomes available. Sierra Club therefore requests that the record be left open for 30 days from the date the RAI response was entered on Adams to allow us to file new or amended contentions based on the RAI responses. If the board would prefer a written motion, we would ask for 7 days to file that motion.
Let me just interrupt you there. You are correct that although it's not in the regulations, 30 days has generally been ruled to be an adequate period of time to respond to new information. So if you file within 30 days a motion for a new or amended contention, that's sufficient. You don't need another motion 7 days from now. Thank you.
Okay, thank you. As I said, the issue here really is the danger from the radioactive waste being stored. The U.S. Court of Appeals for the District of Columbia Circuit said in the first New York versus NRC case regarding the waste conference decision that even though it is no longer useful for nuclear power, spent nuclear fuel poses a dangerous long-term health and environmental risk. It will remain dangerous for time spans seemingly beyond human comprehension. I think that should give us all pause and encourage all the parties in the board to give this case very serious consideration, and I know you will. Thank you.
Thank you, Mr. Taylor. Let me ask you a few questions first about Sierra Club's contention number 1. The first part of that, I believe, is essentially identical to the beyond nuclear contention. Am I correct? In other words, it's challenging the lawfulness under the Nuclear Waste Policy Act of what we called earlier option one, the possibility that is in the application that DOE would take title to the nuclear waste. Am I correct? That's
yes.
the first part of your contention.
Yes.
But there's a second part to contention one, as I recall. And that seems, if I'm reading it correctly, to more broadly challenge the idea of any away from reactor interim storage facility for nuclear waste. And are you still pursuing the second part of that in light of the responses you received, or have you rethought that one?
In our reply, we suggested that the Atomic Energy Act allows the NRC to do not allow.
Thank you for calling the conference center. At any time during this message, please enter your passcode followed by the pound sign. If you Your passcode has been confirmed. You will be joined in listen-only mode.
Resnikov study, which is a study that was based on a fire that took place in the Baltimore tunnel in 2001, and analyzed that from the standpoint if that had been a nuclear issue. And Holtec's argument is that in their environmental report, they cite, I believe it was a 2008 final supplemental environmental impact statement of the Department of Energy in the Yucca Mountain case. And they point out that is very critical, frankly, of the Lamb and Resnikov study, which they basically say, A, at a minimum, shows that it's a worst case analysis, and B, they would say it's flatly wrong. And they say that you don't grapple with that at all in your petition. I think I'm characterizing their position. What is your response to that?
Well, first of all, Dr. Resnikov, who was our expert for this contention and was also the author of the report that's being criticized, he clearly states that he stands by his analysis and, in fact, updated it somewhat for the contention. I'm
not sure I saw it updated. Where is it updated?
On page 25 of our contentions.
Okay, thank you.
And secondly, I think that, quite frankly, Holtec is arguing facts which are not appropriate for this stage of the proceedings.
Well, that's, as you know, the NRC does not make merits determinations on contention admissibility. At the same time, the rules are what the Commission has described as intentionally strict. And the Commission has expressed the view that a party must, for want of a better term, come to grips with the application, the things in the application. And what I'm asking you is, if as Holtec represents, there are criticisms of Lamb and Resnikov, and you're relying on it, but you don't address those criticisms specifically, then do you still have an issue that merits an evidentiary hearing? That's a two-part question. The first part is, do you grapple with the criticisms, and if not, why not?
Well, I guess I grappled with this with the same response I just gave you, that I think Holtec is arguing facts, and Dr. Resnikov stands by his prior analysis. Secondly, it's impossible to, when you're drafting contingents, to anticipate every challenge you're going to get from the applicant. Well, you should have seen this, or you should have talked about that, and it may be things that are not that easy to find that the applicant may know about, but how are we supposed to, at the contention stage, when very early, to say the least, in the proceedings, and with the time limit we have to form contentions, to just survey the universe for everything that might be at odds with what we're contending.
All right, thank you. Let me ask about Sierra Club Contention 8, which is addressed to the decommissioning plan in the application. And did your original petition essentially ignore the fact that Holtec is relying upon a reasonable rate of return on the money that it puts aside for decommissioning? I mean, I think your original contention just missed that. Is that right?
We didn't specifically discuss that, no. We did in our reply, obviously, which I think was appropriate for a reply.
Right.
But it wasn't obvious, to me at least, when I read their funding document, that they were relying to that extent on the interest that would be generated from the fund. And they said up to 3%, so how are we supposed to know exactly what percent they're relying on?
So the application says up to 3%, a real rate of return, I believe. And I could ask Mr. Silberg, a real rate of return. I don't know if you need us, Mike. My question is, when Holtec says a real rate of return of 3%, is that 3% above inflation? Is that what a real rate of return is?
Yes.
Okay, thank you. Well, in your reply, and I know Holtec, I believe, says you shouldn't be allowed to make this argument, but you make an argument in your reply that 3% real rate of return is not necessarily realistic. But do you have any, other than your own view, do you have any support for that position, assuming you're allowed to make that argument?
No.
What, other than your own view, do you introduce any evidence that 3% is not a realistic rate of return?
We just use their own figures, and I think in their answer they said up to 3%. That's where I got that. But you know, when you only have 7 days to file a reply, you can't go find an economist who can do that kind of analysis at the time.
Right. It perhaps could have been in the original petition, but it was not. Let me ask you about contentions 15 to 19, which are various challenges based essentially on geology. And the environmental report states, and I think I'm quoting it accurately, at pages 1-7, maybe 7-2 as well. There is no potential for a liquid pathway because the spent nuclear fuel contains no liquid component, and the casks are sealed to prevent any liquids from contacting the spent nuclear fuel assemblies. And the environmental report further concludes at 4-47 that there is no viable mechanism for off-site migration. Where do you address those arguments in your petition, or where does your expert address those specific arguments?
Well, of course, the expert we had for the hydrology is not an expert on radioactivity, but if you look at our contentions, I think it's 14 and then 20 through 24, we do discuss the possible causes of leaks and breaches in the containers. And even if you look at the SAR that Holtec submitted in their aging management chapter 18, they list like 6 or 8 causes of container breach, and so they are admitting there that there are possibilities of container breach. And as I said, even these new responses to the RAIs that I mentioned in my opening statement I think, go to the issue of the possibility that the groundwater and the radioactivity can come together and cause pollution of the groundwater.
But do you, the quotes I just mentioned from those pages, do you, either in your petition or in your expert statement, do you cite those specifically? Do you address those specifically?
Not specifically.
Okay, thank you. Judge Shapouros.
In your contention two, the staff answer actually to your contention two talks about the fact that the contention deals with the need. His question is
the need, yes.
The need, for the project. In the staff answer, and in your contention, you're focusing on the relative safety of this off-site ISFC in comparison to an on-site ISFC, which exists now in almost every plant that we have. Would you say that the purpose and need for the project can be supported by everything other than the relative safety argument? The staff points out 5 or 6 very, what I would view as very important reasons for the project, but you were focusing on this relative safety issue. So is that a major part of your argument, or would you need that for that contention, or be satisfied with the staff answer?
I'm never satisfied with the staff answer. Well, sometimes I am. There are a few staff answers I was satisfied with. But the point of a purpose and need statement is to determine the range of alternatives that are to be considered. If, as in this case, Holtec is making the claim that the CIS is safer and more secure than on-site storage, and they're dismissing on-site storage basically, and that's a major factor in why they're doing that, that limits the choice of alternatives. They're trying to use the safety factor as a, I believe, key factor in dismissing the on-site storage as a viable alternative, even though they say in the ER, I think it's section 1.1 or 1.2, that the on-site storage is a reasonable alternative, and in fact, in section 4.14 of the ER, they discuss the impacts of on-site storage and find that it's perfectly safe. Well, maybe I'm exaggerating a bit, but they find that it's a safe alternative. So it seems to me that by neglecting the finding of the new storage rule that on-site storage is safe indefinitely, the Blue Ribbon Commission report that says on-site storage is safe, that they are improperly limiting the choice of alternatives.
Well, in the NRC staff, I should say, response, and let's take it as a given that whether it's in an off-site facility or an on-site facility, Those are both options from a safety point of view, which in fact may be true. But let's take that as a given. There are many other reasons for a utility wanting to remove the fuel from their site, and a number of them are discussed in the application. I can't point to specific places, but the staff answered lists those. And one, for example, being to get the fuel off the site so they could return the site to for useful purposes. Wouldn't the purpose and need be satisfied then by those other reasons, as opposed to whether it's safer to have it on site or off site?
But when Holtec uses the safety argument in its purpose and needs statement, it has to be backed up, it has to be supported, and because they have other possible purposes and needs, doesn't take away from the fact that they are using the safety argument as a major factor in their purpose and needs statement, and they are thereby limiting the choice of alternatives.
Okay. Can I go on, or do you want to? You have a series of contentions, basically, I think 15, 16, 17, there's a sort of a group of contentions.
About the groundwater, yes.
About the groundwater and the chemistry of the groundwater. The staff in response, of course, provided the argument that you can't identify a mechanism whereby, you'd have a leak and that leak would lead to all these problems. Isn't it true, however, that in a standalone fashion, you're questioning the adequacy of the environmental report and perhaps even the safety evaluation report or the safety analysis report? In your contention, you sort of focused on, what could happen if there's near surface groundwater and brine present. Wouldn't it be true, however, that if you eliminate all that and just make the argument that you've shown that there's inadequacies in the environmental report, period? Would that be correct?
If I understand your question correctly, you're saying that I could just argue that the environmental report is insufficient whether or not there's any pathway for contamination. Is that it?
Yes.
Well, and I think that's true. Certainly when the environmental report addresses the issue of groundwater and subsurface conditions, and they have to do a thorough, complete, accurate job. And we have shown through our experts' opinion that they have not. I think it was basically the staff in Holtec that raised the issue of whether or not there was a pathway for contamination. But we do believe that our contentions regarding the possible leakage from the containers does provide that. But I think you're right that just the inadequacy of the discussion of the underground water and subsurface conditions would be enough for a contention, which is basically what we were arguing.
Okay, thank you. In your contentions, let's see. In your contentions, 20 through 23, those contentions are dealing with the question of high burn-up fuel. The manner in which high burn-up fuel is being dealt with in this facility, is that satisfactory to you?
Well, in looking at the Holtec documentation, particularly the SAR, which relies to a great extent on the UMAX FSAR, it looked to me like, and I admit I'm not an expert, I'm just a dumb lawyer, but it looked to me like, and our expert has indicated this, that the Holtec documentation doesn't really address the concerns about high burn-up fuel that Dr. Resnikoff addressed. It appears that they're just assuming somehow or other magically that the fuel will be less than a certain temperature in the container, and that's it. But I didn't really see any justification or a credible support for that in the documentation.
Now, we have questions on this for the other parties, and so this is just starting this issue. All right, so are you saying then that the interim staff guidance, I believe it's 11 Rev 3,
yes,
talks about temperature limitations, that if you meet those temperature limitations, that you will mitigate any potential cladding failure effects on the fuel. And it does have separate numbers for the high burn of fuel versus the low and moderate burn of fuel. Are you saying that that's sufficient, or do you feel that that's insufficient?
You mean the staff guidance is sufficient for Holtec to rely upon?
Yes.
Well, the problem is twofold. One is that Dr. Resnikoff pointed out that the staff guidance 11 version 3 says that each site must be taken on its own facts, case by case, a determination that wasn't done here. And secondly, as I said, Holtec, it appears to me, has not adequately justified the statement that the temperature will be below the regulated, the guidance standard.
Okay. Have you seen the aging management program? I think it was...
It's Chapter 18 in the SAR?
Chapter 18 in the SAR, but there's also a separate submittal of it. I forget which attachment it was to the license application. Do you feel that that's adequate with respect to such things as the CEC as you mentioned earlier, do you think the aging management program is adequate to accommodate these various effects? It also includes, by the way, groundwater monitoring, including, I believe, for brine. Now, one of the questions that we'll follow up with is if they're only monitoring the groundwater that the ER says is there, then your contention 15, I think, which says that there's probably groundwater that you haven't found, it would be relevant. But do you have any comments at all about the adequacy of the aging management program?
My concern about the aging management program is that, first of all, it would, as we said in some of our contentions, the CFC for the UMAX system is based on a design life of 60 years and a service life of 100 years, I believe. The license for the facility, according to Holtec, would be 20 years, and then they hope to get a 40-year extension. That's only 60 years. So what happens after that? The aging management plan, it looks like to me, is strictly a voluntary proposal by Holtec based on what the conditions might or might not be 100 or 200 years from now, depending on how long this site has to be used. And there's no NRC oversight as far as I can tell. It looks like it's totally voluntary with no NRC oversight after the licensing period. And so that's our concern, that we're relying on Holtec's guess as to what they might need later on. It's totally voluntary. We just don't have the assurance that it's really going to catch problems or to do anything about them sufficiently if they do find problems.
Mr. Taylor, we're not quite done with you, but Judge Arnold has advised that he has a number of questions. I believe Judge Tricouros has a few more, and we've gone almost 90 minutes now. So we'll take a break until let's say promptly 10:40, 20 of 11, and we will resume at that time. If we could come to order. All right, we're beginning with questions again for Mr. Taylor. If we could have some quiet so Mr. Taylor can be heard. We have one last logistical issue I probably should have mentioned at the outset. For the benefit of our speakers, who have to stand for quite a while here. I'm not sure if we'd been able to use the federal court, whether the space would have been that much better, but we're making do as best we can. In any event, we have put water out. If any of the speakers, as they come to the podium, would like to pour themselves some water, they are more than welcome to do that. So we're continuing with questions for Mr. Taylor, who represents the Sierra Club. And we're going to start at this point. I think we'll come back to Judge Tricouros, but we have from Judge Arnold some questions.
On page 8 of your petition, you list the 10 CFR 2.309F criteria for an admissible contention, and that included item 3, that the contention be within scope, And item 4, that the issue be material to the findings the NRC must make. But then as I looked through, I think there was only one of your contentions that actually addressed that it was within scope and material. So what are we to assume about the other contentions that you did not address scope and materiality?
I guess I wasn't under the impression that you had to specifically say that as long as the contentions were, in fact, within scope and were material.
Okay, but your position is they all are within scope and all are material?
Yes.
Okay. Throughout the petition, you make numerous references to the Nuclear Waste Policy Act. Now, do you consider that an NRC licensing board is the proper platform to challenge whether something violates the Nuclear Waste Policy Act?
As Ms. Curran said, that's a good question. Frankly, it isn't clear to me. I certainly would defer to Ms. Curran in her argument that this board may have no jurisdiction to decide the issue of whether the Nuclear Waste Policy Act precludes the licensing of this facility. On the other hand, the Commission, through the Secretary, clearly said that this board is the proper venue, so I guess we're between a rock and a hard place. But I chose to bring the contention to the board within the 309 proceeding. So maybe the courts will have to straighten that out. I don't know.
On your contention 1, the challenge to the authority to license the Holtec CIS facility. Now, as I see it, you say that the NRC does not have the authority to license the CIS facility under the Atomic Energy Act, and when you discuss the basis, that's focused on who would hold title to the spent fuel. Now, on page 13 of the petition, you cite Holtec stating it would build the storage facility, quote, upon successful completion of an agreement with the Department of Energy and or one or more utility companies to store spent fuel. And immediately thereafter, you say, all of the foregoing statements by Holtec and its representatives clearly show that Holtec intends for DOE to take title to the waste. So, as concise as you can, why is not option B viable?
The documentation, particularly the ER, does not provide any indication at all that the nuclear plant owners would agree to retain title. If Holtec is using that option as a possibility, they need to tell us, tell the board, tell the Commission what basis they have to say that the nuclear plant owners would want to retain ownership of the waste. And they've not done that.
And let me ask you this. I asked Ms. Curran earlier. To your knowledge, does the DOE currently hold title to spent fuel or greater than Class C waste?
I don't know off the top of my head. I don't know.
Okay. Now, Beyond Nuclear has submitted a petition that has a very similar contention. And I'm just going to state what I see as the difference between your contention and the Beyond Nuclear contention. Now, from what Ms. Curran said earlier, her belief is when a contract has two options for fulfilling some requirement, and one of those options is just plain old illegal, that contract is not valid. Whereas your argument seems to be that there are two options. One is illegal and the other one is just unsupported by the petitioner. Is that how you see it?
I guess I hadn't considered that my contention and Ms. Curran's were different in that respect, but certainly our main contention is that all the way along, based on what Holtec personnel had said before the application was filed, what they said in the ER, that a DOE would take title, and now what they've in fact said in a recent statement to the public, in a newsletter that went out, that depending on DOE, that we believe that the option B, as you call it, that the plant owners would retain title, is not something that the Holtec has substantiated would even be a possibility, and they have not really convinced anybody, to my mind, that that is a distinct possibility.
Okay. Now, Ms. Curran also stated that her contention is not within scope and is not material. Now, considering the similarity of two contentions, why is yours within scope and material?
My understanding is that in a 2.309 proceeding, you can always challenge a legal issue, and I believe that's what we're doing here. Whether the board and thus the commission can legally grant a license in this proceeding, and so as we see it, it's a legal contention that is appropriate for this board to consider.
Contention 2, you challenged the application statement that the CIS is safer and more secure than storing waste at reactor sites. If the ER had simply said that it is safe and secure rather than safer and more secure, would this contention go away or would it still be there?
Well, the inference clearly is in the ER that they're dismissing the on-site storage alternative by saying that the CIS is safer and more secure. And I think that's very clear in the ER.
Okay. On page 18 of your petition, you state the purpose and need statement under National Environmental Policy Act is important because the purpose and need statement necessarily dictates the range of reasonable alternatives. Specifically, what alternatives are you concerned with?
On-site storage.
Just, okay.
Yes.
To your knowledge, you were talking about HOS, which is what does HOS stand for?
Hardened on-site storage.
Okay. Has that been implemented at any ISFC currently?
It certainly is a technology that has been studied and recommended. In fact, we cited Dr. Gordon Thompson's paper on that. I don't know offhand whether it's been implemented anywhere or not.
Contention 3 also is concerned with the statement that the CIS is safer and more secure. Now, on this contention, on page 22, you state Holtec, contrary to NEPA, has not established a purpose and need for the CIS project. But when I look at ER Section 1.2, specifically purpose and need for the proposed action, I see, quote, many policymakers and stakeholders in the communities that host shutdown reactors want to have the spent nuclear fuel removed to complete decommissioning of the site and to allow for more beneficial uses of the land. Now, that seems to be a purpose and need that is totally independent of that safer and more secure issue. How is that not a valid purpose and need?
Well, as I mentioned to Judge Cross, I think it was, when Holtec cites quite significantly that the alleged safety and security of the two alternatives, on-site versus the CIS, is made a distinct part of the purpose and need statement, that unfairly limits the choice of alternatives, basically the on-site storage. So I don't think the Holtec can use that as a major purpose and need, and thereby more or less dismiss on-site storage, and then say, oh, well, there are other things that we've mentioned too. I think if they use the safety and security aspect, they have to justify it and that they have to live with that.
Okay, contention 4 has to do with transportation from a reactor to the CIS sites carrying substantial risk. You state that these risks must be evaluated in the ER, and that ER Section 4.9 does not adequately address these. On page 25 of your petition, you provide your estimate of dose to the population following a major rail accident. This estimate is 1,250 times the estimate contained in the ER. You state here, as shown in Dr. Resnikoff's declaration, the updated estimate of approximately 20 million person REM due to a major rail accident is approximately 1,250 times Holtec's estimate. I looked at the Dr. Resnikoff's declaration, and it was a one-page declaration that contained no calculations or numbers, only the statement, I have performed calculations and analysis sufficient to reach opinions and conclusions regarding safety issues inherent in Holtec's proposals. Did I miss something? Was there another paper that I...
What Dr. Resnikoff's declaration said was that he had reviewed the contention, which he helped draft, and that he is adopting that contention as his declaration, basically.
Okay. So basically we have a conclusion without any numbers behind it. I got it. You fault the environmental report for its reliance on the generic environmental impact statement of continued storage of spent nuclear fuel, and that is New Reg 2157. And you have several reasons for that. One of them is the GEIS assumes a consolidated facility of 40,000 metric tons of spent fuel, not for 100,000 tons. What I want to know is, how does the amount of spent fuel sitting at the destination affect the risk of transportation?
The more fuel you have at the destination, the more transportation trips there are going to be, and thus the risk increases.
Okay, it's simply, it's a multiplier.
Right.
100,000 versus 40,000, the risk would be 2.5 times greater.
Well, I don't know if it works out quite that way, but yeah, it would be much greater, yes.
The GEIS assumes a dry transfer system at the destination storage facility. How do the facilities at the end affect the risk during shipping?
I think probably that was not exactly addressed to the transportation. It was more to dealing with the waste once it got there.
Okay. The GEIS does not account for deterioration of the railroad infrastructure. Now, what evidence is there that this deterioration and the actual railroad infrastructure is in worse condition than assumed in the GEIS transportation risk analysis?
What we noted, first of all, in our standing declarations that the rail system, at least in New Mexico, has deteriorated. We noted two recent, at that time at least, rail accidents that were caused by deteriorated infrastructure. So that's the basis.
Mm-hmm. But hasn't there always been rail accidents?
Well, not necessarily.
Does the evidence show that there's recently more accidents than in the past, per shipping mile?
Dr. Resnikoff in the contention notes that there have been more rail accidents and more rail fires.
Mm-hmm. Okay. Petitioner's fault environmental report section 4.9.4, due to its reliance on the FEIS for the ISFC in Toole County, Utah, and that would be New Reg 1714. And the petition states that this EIS focuses on local transportation and is irrelevant for cross-country transportation. Is there anything wrong with using that EIS for local transportation in the region of the facility?
I think when you try to equate two separate situations, you're taking a risk. We're talking about risk, I guess. You're taking a risk that the case-specific situation may be different, and you need to be really careful in using another EIS to just determine what should be in this EIS.
Contention 6, the discussion of the no action alternative. You claim it does not consider adequately the on-site storage can. Would implementing HOS at current ISFCs actually be a no-action alternative? It seems to me that would require a licensing action in and of itself.
It would be a no-action alternative concerning this project, because this project weren't built. The on-site storage supplemented by HOS would be a viable alternative. But it would be no action in terms of this licensing proceeding.
Okay. And implementing HOS at existing ISFCs, you would admit that it would not achieve the goal of having an ability to return decommissioned sites to natural state, but then you also say that that's not a reasonable need for it because it's limiting the selection of alternatives, right?
The fact that they're dismissing the on-site storage, I think, is a violation of purpose and need statement, or at least what it should be.
Contention 7. Actually,
the way I read it, seemed to be two contentions. One was Holtec's ER sections 1.1 and 2.1 mischaracterize both the Blue Ribbon Commission's report's conclusions and the relative risks of CIS versus on-site storage, and two, the EIS must independently and fully address the relative risks and benefits of both storage options. That's what I seem to get out of it. Question. You cite ER sections 1.1 and 2.1 claiming that in them, Holtec says the, quote, purpose and need is dictated a great extent by the BRC report. That's what you say. Now, I see ER section 1.1 providing history and background, and section 2.1 discusses the no action alternative. And it is section 2.1 that provides the purpose and need. So I'm wondering why we should give more weight to inferences derived from sections 1.1 and 2.1 instead of just reading the explicit purpose and need provided in section 1.2.
Well, I think you have to read them together, and I think, I can't cite the exact sections at the moment, but there are several places in the ER where Holtec refers to the Blue Ribbon Commission report, and that this proposed project would be consistent with and support the BRC report.
Contention 8. You state the decommissioning plan submitted by Holtec does not contain a funding plan that provides reasonable assurance that funds will be available to decommission the CIS state. Now, I looked in the Code of Federal Regulations for the requirements, and it's 10 CFR 72.30, and in paragraph B, it requires a decommissioning funding plan that must contain, and there's a list of things that must contain. The first one is information on how reasonable assurance will be provided. So it makes it sound to me as though the application doesn't have to supply reasonable assurance, just information on how it's going to be supplied in the future. Do you read that differently than I do?
I do. I think that certainly, if that means anything, it means we need to see in the documentation some assurance right now that there is a funding plan that will assure adequate funding for decommissioning. Otherwise, I can't see how that really means anything.
Item 4 in that list of what it contains is a description of the method of assuring funds for commissioning. Now, that doesn't sound to me like a detailed funding plan, but just kind of the words, and we'll use this, well, basically the funding plan that's in there has a lot of contingencies, and it's not one specific plan. Do you object to the way it's worded now with contingencies?
I think that if there are contingencies, they would have to be very specifically stated and still give some assurance that there will be adequate funding for decommissioning.
Okay. And then there's an item 6, and this one I'm confused on. The decommissioning plan must contain a certification that financial assurance for decommissioning has been provided. Now, I see your challenge being more challenge to this, that there's no certification that the financial assurance is there. Would that be a correct interpretation?
Well, that's certainly an important part of it, yes.
Okay. Contention 9. The ER must examine the environmental impact of the containers being used beyond their approved service life. Now, I look at 10 CFR 51.23B, which is the continued storage, and in relevant part it says, the environmental reports are not required to discuss the environmental impacts of the spent nuclear fuel storage in an ISFC for the period following the term of the ISFC license. Now, I believe that these canisters are certified for longer than the ISFC license. So how can I not consider this contention to be a challenge to this rule?
The continued storage rule is based on several assumptions that we've set out in our contentions and our reply. In terms of the quantity of waste, the rule is based on 40,000 tons. This is over 4 times that much, I guess. It's based on having a dry transfer system, which there's no indication in this one that there is. There is no indication in the continued storage rule that it actually considered the problems with high burnup fuel. So all of those assumptions that upon which the rule is based are not present in this case. And as I said in my reply as well, the continued storage rule still provides for site-specific considerations, which we need to look at here, based on those assumptions that are not present here, but that were used in creating the rule. It's like you buy a can of vegetables at the store and it says the expiration date is such and such. After that expiration date, a lot of things go into whether or not you can still eat that a can of vegetables or not. It may be okay, maybe not, and we need to look at the specific can of vegetables to determine.
Well, are you therefore saying that the continued storage rule only applies to ISFCs that match exactly the ISFC used for the study which developed the GEIS for continued storage?
Yes, I believe that if you look at the GEIS, it says it's specifically based on those assumptions.
In that case, one of the assumptions was the dry transfer facility, and I know in one of your contentions you mentioned that there are no dry transfer capability at any ISFCs. So basically, you believe the GEIS and that rule applies to no storage facility current in the United States?
Well, if they had ATS, it might apply, but there's no indication here that the Holtec plans to have one.
Contention 10. NRC regulations specify that greater than Class C waste must be disposed of in a geologic repository licensed by the NRC. So you're saying that the spent fuel storage facilities are licensed under 10 CFR 72, and in 72.3, an ISFC is defined as a complex designed and constructed for the interim storage of spent nuclear fuel, solid reactor-related greater than Class C waste, and other radioactive materials associated with spent fuel and reactor-related greater than Class C waste storage. So since the regulation states that this greater than Class C waste can be stored, why must Holtec treat this as disposal of greater than Class C?
Because, as I've said in other contentions, this may, in fact, end up being a permanent facility if there's no geologic repository ever created. And frankly, I'm speculating here a little bit, but if this facility is licensed, and also the one over in Texas is licensed, that may take the political pressure off finding a permanent repository, and which would further support the idea that this may in fact become a de facto permanent repository. And as I indicated in my reply, if you look at the definition of a disposal, it would apply to this if it in fact is not just interim. And so that's what we were suggesting there, that there's no indication that this will just be an interim storage facility. It may be a disposal facility and therefore cannot accept the GTCC waste.
Okay. Contention 11. Both the ER and the SAR are inadequate in that neither evaluates the potential for and consequences of an earthquake. On page 44 of your petition, you state regarding oil and gas drilling, this drilling activity makes the underground area unstable and induces earthquakes. Now, do you have support for that statement, that the oil and gas drilling does induce earthquakes? I didn't see any support in
Yes, that Stanford study that is attached as an exhibit supports that.
Now, did that just concluded that it caused more earthquakes, or did it affect the severity of earthquakes?
They were finding new faults as a result.
Mm-hmm. Well, in SAR, okay, on page 47, you state the SAR 2.6 refers only to historic earthquake data. Is there any earthquake data that is not historic, or were you saying they should be looking at analysis as well as historic data?
I mean, certainly analysis would help, but their data was certainly more remote than the Stanford study that we provided, and the evidence of recent gas and oil fracking.
Mm-hmm. Contention 13. The credibility of those portions of the ER prepared by Tetra Tech is in question. Now, on page 52 and 53, you discuss a petition to the NRC pursuant to 10 CFR 2.206, asking the NRC to revoke Tetra Tech's license. Now, I didn't see any. Did the NRC revoke Tetra Tech's license or put any limits on their license as a result?
The last thing I had at the point that we filed the contention was that the NRC had fined Tetra Tech $7,000 and found that Tetra Tech engaged in a deliberate falsification of soil sample surveys. At that point, the 2.206 petition had not been finally decided.
Oh, do you know if it has now, or still?
I don't know for sure.
Contention 15. The ER fails to adequately determine whether shallow groundwater exists at the site of the proposed CIS. Okay, I have only, let's see. 10 CFR 51.45 requires the environmental report for an ISPC contain a description of the environment affected. Now, how would the site affect the groundwater? Or are you you're worried about the site affecting the groundwater or the groundwater affecting the storage facility?
I think the primary focus, although the questions that you gave us before the hearing triggered another alternative probably, is that that it may run both ways, but originally our concern was that a leak or a discharge from the facility would impact the groundwater. But I suppose brine in the groundwater could also impact the facility.
Contention 16. The ER does not adequately address basic questions regarding the subsurface movement of brine. This is another similar question. Are you worried about the brine affecting the facility or the facility affecting the brine?
The brine affecting the facility, and that goes to the RAI that I was mentioning in my opening statement.
Okay. Contention 19 about the Packer tests to estimate hydraulic conductivity were not conducted properly. Now that's okay. That's a way of measuring the hydraulic conductivity. Can you tell me how has the hydraulic conductivity been used in the application? Do they specifically make calculations using the results of the Packer test?
What the contention says, based on Mr. Rice's report, is that GEI consultants who were hired by Holtec to conduct Packer tests at the site to determine the conductivity, GEI claimed to have used the testing methods set out in the U.S. Bureau of Reclamation Field Manual. But as Mr. Rice notes in his report, GEI does not appear to have followed several recommendations in the manual.
Mm-hmm. Well, what I want to know is, have they used the results of the test in any significant way in the application? Or is it just a number that they have available?
I can't tell you that specifically. I don't know.
Mm-hmm. Contention 21. There is no experimental support for the safe transportation and storage of high burn-up fuel. Actually, I don't have a question on that.
Good.
Quickly on contention 23, Holtec has not described how degradation that leads to gross rupture of the fuel would be detected. Holtec has not specified how it will address the safety issues inherent in the gross cladding defects due to high burn-up fuel. Do you know, is there somewhere a requirement that a storage facility be able to detect gross failure of the fuel clad?
Well, we're basing this on Dr. Resnikoff's input, which is in the contention. But certainly, failure of fuel or failure of the cladding would certainly be a safety issue. And I don't think we can disagree with that.
Well, Bob, when we get to Holtec's turn for questioning, we'll ask.
Okay.
Contention 24, neither the Holtec ER or SAR contains sufficient information to assess the risk of shipping the MPC 37 canisters. And my question is you state specifically insufficient information to assess the risk of shipping the canister. I get from that there's an assertion that the ER or the SAR are required to provide sufficient information for an independent assessment. Is that your statement, or?
Well, sure. I mean, that's the purpose of the ER, and then, of course, the EIS later on. But certainly, there's an NRC regulation on how the NRC is supposed to prepare the EIS, and the first thing they look at is the ER. And so they have to start there, and certainly you want enough information that, first of all, the NRC, in preparing the EIS, can evaluate the situation, and then the whole purpose of NEPA is for the public to be informed.
Except that the public is, these calculations to evaluate the integrity of a canister during a shipping accident, that's a detailed calculation that I can assure you most of the public can't make. But I mean, no matter how many details they have.
Well, me either. But if the information is not there, a member of the public cannot have an expert like Dr. Renskoff or somebody else make that calculation who's capable of doing it.
And I'm to the end of my questions for you.
Thank you.
Thank you, Judge. Judge Koukouros, do you have some more questions?
Yeah, I think so. Let's see, with respect to contention 16, there's a reference to the Rice Declaration where it talks about the presence of brine, but it doesn't talk about corrosion. Is that correct? You're not relying on the Rice Declaration for an argument of an expert witness on corrosion, right?
Right, yeah. We're relying on the other contentions where Dr. Renskoff talked about the danger of leaks from the canisters.
Right. In contention 17, you talk about fractured rock, and you say these fractures could allow radioactive leaks from the CIS facility to enter groundwater, or for the brine described in contention 16 to corrode the containers containing the radioactive material. And that's really all you say about it. It wasn't clear to me if contention 17 was the environment affecting the canister or the canister affecting the environment, or both, I suppose, for that matter.
Again, I think it probably goes both ways, but at the time, the emphasis was on leaks from the canisters entering the groundwater through the fractured rock.
Okay. But in all of this, you've never identified a leak scenario, right?
Well, as I say, we have in the contentions regarding the safety of the containers. But Mr. Rice was not an expert on that, so he was just talking about the underground conditions that would be impacted or would impact if there were a leak.
Okay. Contention 20. Is this a contention of omission in your evaluation that the ER does not specifically discuss high burner fuel?
Yes.
So you consider that a contention of omission?
Yes.
Okay. And how would you expect the subject of high burn of fuel to be discussed in the ER?
Well, just the way Dr. Resnikoff did, that the high burn-up fuel can cause cladding failure. There has to be information about how it's packaged in the containers and that kind of thing.
And the existence of a high burn of fuel aging management program, an aging management program specific to high burn of fuel, that which I think is a SAR issue, is not adequate. You think it should also be discussed in depth in the ER.
I don't know that it needs to be discussed in the ER, although I think it certainly could be.
We just discussed that it's a contention of omission, therefore the ER.
Yeah.
That you meant it that way, right? Yeah. Okay. Contention 21. It says the staff recognizes that data is not currently available. This is talking now about high burn of fuel. The staff states that until further guidance is developed, the transportation of high burn up commercial spent fuel will be handled on a case-by-case basis. That's quoting from the ISG 11, I guess. Holtec has not met this test. High burn of fuel should not be transported until Holtec can assure it is safe. And then you go on to say the ER must address real-life accident conditions based on the specific facts of this case. And my question is, how does the first part of that apply to the Holtec application? And what's the difference between hypothetical accident conditions and real-life accident conditions? It's not the first place that I've seen this. I think you've used it in more than 2 or 3 places, actually. Why don't you address the hypothetical versus real life first?
As I understand what Dr. Resnikoff was saying is that there could be models, for example, or maybe something taken from some other situation, like we were talking about the PFS EIS being used for this proceeding, versus using a data that would more accurately mirror the situation that we have here and the facts that we have in this case. That's my understanding.
So you're saying that what you define as a hypothetical accident condition is a computer code analysis?
Yes, I think that's what Dr. Resnikoff had in mind.
Okay, and that wasn't clear. And the other, what you referred to as a real life condition, is an actual physical test? along the lines of Part 71 requirements for transportation cast testing? Is that?
I don't know if it need to be quite that elaborate, but that's certainly something toward that nature, yes. And your position, and I think you said this earlier, this case-by-case business that's discussed in the interim staff guidance, you're claiming that hasn't been fulfilled by Holtec. Right.
And until that does get fulfilled, you're claiming that high burn of fuel should not be transported.
Right. Okay. Or at least Holtec needs to make a better showing of how they're addressing the high burn-up fuel.
Okay. When you talk about transportation, and I'm referring now to your contention 22. Are you talking about the initial transportation to the facility from the reactor site? Are you talking about transportation after a long period of time to the permanent disposal facility, or sort of all, and also there's transportation within the facility itself, which certainly is of concern to people. Are you talking about one or all of these?
Well, to a certain extent, all of them, but I think primarily the transportation from the reactor site to the facility.
Okay.
But you're correct. There are certainly issues in all of those, but I think probably the biggest risk, of course, is the longest distance of transportation, which would be from the reactor sites to the facility.
And the concern with high burn of fuel that we've been discussing is transportation related. Is there also a concern with high burn of fuel for lengthy storage?
Yes. As I understand it, there can be cladding failure and other problems that don't manifest themselves initially, but with time would appear that would probably be caused by high burn-up fuel.
Okay. But overall, with all these things we've been discussing about high burn of fuel, there really is no satisfactory discussion in the environmental report or even the SAR regarding this subject.
Right.
And you make that assertion in not just one contention, but 3 or 4. I think actually at least 4 contentions, 20 to 23 in general, is discussing that subject.
The high burn-up fuel, yes.
Right. Okay. So one other item. We have a license life, we have a design life, we have a service life, and I'm sure the staff can give me details about what each of those are relative to each other. But would it not be true that you can't get to the design life or most certainly not to the service life, which is longer, unless you do license renewals of the initial license. So that, for example, if you have X years of initial license and you want to renew that for 40 years, we have to go through this process again. We have to go through a license renewal process, which I believe would include all of the environmental reviews, safety reviews, et cetera. So this idea of long-term is going to be revisited again more than once, correct?
Well, as I read Holtec's the documentation, both the environmental report and the SAR, they're talking about the initial 20-year license period and one 40-year extension. They don't talk about anything beyond that, and then they go into the aging management program, which, as I said, expresses a concern to me because there's no regulatory oversight. It appears.
Well, perhaps I will ask the NRC this question, but it seems to me you can't go beyond the 60-year point without a license renewal. So, what I've said regarding the revisiting this entire thing would have to occur. Does the staff want to comment on that?
I apologize. Could you clarify your question or repeat it?
Right. Each of the stages of licensing requires a detailed environmental and safety analysis review. We're now dealing with the initial license, but if they did apply for the renewal license term, which is 40 years, we would require this process to be repeated at that point, correct?
Yes, sir.
And that would also be true of a second 40-year license renewal.
Yes, sir.
Okay, so there is no way to get to the service life without at least two more license reviews, environmental and safety.
Are you addressing it to me?
Yeah.
Okay, thank you.
Thank you.
The projected life of this facility is only 120 years. As I read the Holtec documentation, and again, as I said, I don't see any indication that they plan to get a license after 60 years, which, you're right, that creates a certain contradiction, but I think it's up to them to clarify that. The burden's on them. But then what happens after 120 years? If there's still waste there and they haven't got a permanent repository, I think we just have a lot of questions and problems here that haven't been addressed by the Holtec documentation that your questions certainly raise.
Well, perhaps we will ask that question of Mr. Silber when his time comes, rather than do that now. But it is a sort of an interesting question. But clearly, every renewal will require a detailed environmental review and safety analysis review, and there will be some board, most certainly not us, discussing that at that time, and you will have all these same opportunities at that time. All right. Thank you.
Thank you.
I'm good.
just one more question,
Promise?
at least for me. Just a follow-up question on contention 4, Sierra Club contention 4. Judge Arnold made the statement that, speaking, I believe, of Dr. Resnikoff's declaration, that there are no numbers in it. And I want to clarify, my understanding of your position is that Dr. Resnikoff has submitted either a sworn declaration or a declaration subject to penalty of perjury that asserts that he has read the contention that you have signed, and that he, in fact, partly drafted, you say, but in any event, he's read that, and subject to penalty of perjury, he is adopting your language. He is adopting the language of that contention, which contains numbers. Now, we may decide that the analysis in the contention that leads to those numbers is adequate or inadequate, but those numbers are incorporated, if you will, into his sworn declaration. Is that my understanding of your position?
Yes. He and I worked on the contention together. I drafted the contention, sent it to him. He said it was fine, and he signed the declaration adopting that contention.
Okay. That's just, if you're not familiar, that was an issue, actually, that came up in the Yucca Mountain contention admissibility phase, in which both Judge Kouros and I were on 2 of the 3 boards. And that was, we adopted the view that as long as there is a sworn declaration subject to penalty of perjury incorporating the language of the contention, that is adequate. That was challenged by the DOE, but all 3 boards went the other way on that, and the commission affirmed. So I think that is a practice that is permissible.
Yeah.
You've got to have your analysis either in the sworn declaration or in the contention adopted, or both. But so it doesn't work if you don't have it either place. But it's okay to have it either place if that is the situation. All right. Dr. Arnold? No. Judge Kouros? It is now about 11:15, a little after, actually. So I think we might as well take an early lunch. And as I said, we'll take a fairly long lunch break so people can get out of this building and find places to have lunch. And let us plan to resume promptly at 1:15 for this afternoon session. Thank you.